discrimination, race vilification, and offensive content have become an increasing problem in today's society. With the drastic rise of digital media, offensive content has become increasingly easy to spread online. This has led to lawmakers attempting to curb this harmful content by introducing laws such as the Racial Discrimination Act of 1975, or the RDA, that regulate this kind of content. These speech regulations highlight a broader debate on the conflict between the spread of hatred and the freedom of speech.
Offensive content is any published or broadcast content that is likely to be upsetting, insulting, or objectionable to some or most people. With the growing platforms of people like Donald Trump, Pauline Hanson, Fraser Anning, and Alan Jones, racial discrimination and vilification has been at the forefront of everyone's minds. Racial vilification is the act of saying or writing unpleasant things about someone or something in order to cause other people to have a bad opinion of them, on the basis of their skin colour, race, or ethnic origin. When producing material, media professionals must ensure they do not act in a way that racially vilifies people and causes offence. The Commercial Television Industry Code of Practice provides that commercial television must not broadcast material that is likely to perpetuate or provoke intense dislike, serious contempt, or severe ridicule against a person or group of people. Similarly, both the MEAA and AANA Code of Ethics provide a clause prohibiting targeting people based on personal characteristics such as race.
Someone who is no stranger to this kind of offensive content and controversy is Andrew Bolt, a conservative political commentator for the Herald Sun. In a Herald Sun article published in 2009 entitled "It's So Hip to Be Black," Bolt describes and criticises what he claims is a trend of people choosing to identify as Aboriginal. He specifically referred to 18 individuals who fall under this trend and questioned their self-identification as Aboriginal persons. Pat Eatock brought proceedings against Bolt, arguing that the articles conveyed offensive messages about Aboriginal people by challenging their identity. Ms. Eatock specifically argued that the articles written by Bolt violated Section 18C of the RDA. So what is this RDA that keeps being mentioned?
The Australian Human Rights Commission describes the RDA as a statute that makes it unlawful to discriminate against a person because of his or her race, colour, descent, national origin or ethnic origin, or immigrant status. The RDA's purpose is to protect people from racial discrimination by making racial hatred unlawful. Section 18C of the RDA states, "It is unlawful for a person to do an act otherwise than in private if the act is reasonably likely, in all the circumstances, to offend, insult, humiliate, or intimidate another person or a group of people, and the act is done because of the race, colour, or national or ethnic origin of the other person, or of some or all of the people in the group." Bolt defended himself by claiming that he fell under the exemptions highlighted in Section 18D of the RDA. Section 18D provides exemptions for people who may breach Section 18C. Bolt argued the article was published in good faith in the course of any statement, publication, discussion, or debate made or held for any genuine academic, artistic, or scientific purposes, or any other genuine purpose in the public interest, or in making or publishing a fair comment on any event or matter of public interest if the comment is an expression of a genuine belief held by the person making the comment.
The Federal Court found that Bolt's remarks conveyed that fair-skinned Aboriginal people with predominantly European heritage were not sufficiently Aboriginal to identify as such, instead doing so for career opportunities or political activism. The court applied the objective reasonable person test in determining the reasonable likelihood of causing offence, also considering the negative colonial history of racial categorisation. The court found that it was reasonably likely that the 18 Aboriginal people named in the article would be offended or insulted as their identity is being challenged. Hence, the messages conveyed by Bolt were reasonably likely to offend, insult, humiliate, or intimidate another person or a group of people. Also, based on the content of the article, it was found that Bolt wrote the article because of the race, colour, or national or ethnic origin of the people. Therefore, Bolt satisfied Section 18C 1A and B of the RDA, therefore contravening Section 18C as a whole. Regarding Bolt's claim that he was exempt under Section 18D, Bolt's article may have been a comment on a matter that was potentially of public interest. Despite this, the court found that he did not act reasonably and in good faith, and therefore did not come under the relevant exemption. The court took into account the potential harm of the article and the lack of care and due diligence taken to minimise offence.
A similar case with the opposite outcome was Brofo and HREOC and another 2005. The case regarded a cartoon published in the West Australian newspaper that depicted the head of Yagan saying, "Crikey, give me a warm beer and a quiet pommy pub any day," with accompanying derogatory political commentary. The Australian Human Rights Commission dismissed the complaint as the publication was not reasonably likely in all the circumstances to offend a reasonable reader. Despite the content being offensive, it was not sufficient to breach the RDA. Further appeals to the Federal Court and the High Court were also dismissed.
Now, how does this relate to the bigger picture?
The issue of regulating offensive content and freedom of speech often conflict. Freedom of speech is the right to express one's opinions without censorship, restraint, or legal penalty. This right is recognised in Article 19 of the UDHR, however is not expressly recognised in Australia. Regulation on speech that carries legal penalty contradicts this right, however the ICCPR clarifies reasonable restrictions. These are laws that protect people's rights, their reputation, national security, public order, public health, or public morals. Thus, the RDA contradicts the right to freedom of speech, which is foundational to a liberal and democratic state. However, not all speech should be protected, especially that which racially discriminates or vilifies. This is evident in the case of Eatock and Bolt. However, the Australian focus on freedom of speech is maintained as provided in Brofo and HREOC and another.
The practical implications of Eatock and Bolt on the media is twofold. The decision outlines that media professionals are expected to understand the meaning they convey and the potential to cause offence in their work. It also highlights that journalists are protected under the RDA given they do act in good faith and without intent to cause harm or offence. Importantly, articles are not in breach of Section 18C by merely covering racial identification. It is highly important the contents of their work and the intent behind it. More generally, media professionals must not act in a way that racially vilifies people, as this causes offence and harm to vulnerable groups of people.
People should take Bolt as an example of what not to do. As such, Eatock and Bolt highlights the positive Australian approach to protection against racial discrimination, despite the potential conflict with the freedom of speech.